Hello guys, welcome to Lopitra YouTube channel. I am Bhavna here. Today's topic is about section 113 to section 115 of CPC, Civil Procedure Code 1908. Let's just see what are these sections and why are these sections and what's the main objective to include this section in our CPC. Section 113, section 114 and section 115 of CPC says about reference, review and revision of the proceedings in our cases. Reference, review and revision. Section 113 is reference, section 114 is review and section 115 is revision. Let's just know the object of why this section 113 to section 115 implemented in our Civil Procedure Code 1908. Everyone is a human being and judges are also human beings. They commit a mistake, error, something or other thing. To rectify these mistakes and to provide a fairness and accuracy in our justice system, these section 113 to section 115 are included. Without just a small mistake can cause a huge loss. To rectify these and to provide fairness and accuracy in our justice system, these sections are included, which section 113 is reference, section 114 is review and section 115 is reference as per CPC 1908. Let's just see why these sections and how these sections can be included. A party who is offended by the decision of the court. A party who is offended by the decision of the court can reach out the higher courts by the way of appeal against the decision given by the trial court or lower court. A party who is offended by the decision given by the lower court can approach the high court or the other higher courts to by the appeal. In case where there is a prima facie error or technical procedural ground, in technical or procedural grounds, the parties are not required to file a fresh case and appeal. In such cases, CPC has provisions of reference, review and revision under the section 113, 114 and 115. So, these sections are given by the lower courts to higher courts where there is a procedural ground or there is a prima facie error in technical or procedural grounds. Remember these point. Prima facie error in technical or procedural ground occurs in a case, then there is no need to appeal. There is no need to go for appeal or as a fresh case. This can be comes under section 113, section 114 and section 115 of CPC. Reference, review and revision. Let's just see what is reference, what is review and what is revision. Let's just see section 113. Reference. Section 113 says about reference. Reference means to refer a case. Section 113 of CPC empowers a subordinate court to state a case and refer the same for the opinion of High Court. Okay, to refer the same to the High Court for its opinion. Such an opinion can be sought out when the court itself feels some doubt about a question of law. If suppose a subordinate case has a doubt upon some case, then it can refer it to the High Court for its case and its clarification. The reference can only made by a court, but if there is a doubt in it, the subordinate court can use its right to reference in the following situations. In a case of any question arising in the court at the time of entertaining the suit, with the respect of validity of time of any act, rules, orders and ordinances, etc., there should be a raising doubt in the court where the court has opinion or feels that the provision of any law is invalid or not in the power of court, where subordinate court has there is no power about the case. It is a doctrine of ultra vires and the High Court or Supreme Court must have not made such question on the provision of law is invalid, where High Court or Supreme Court has not made any provision about its validity or non-validity. The court feels that it is important to take the reference of High Court for ascertaining the validity of provisions mentioned in the law before disposal of any case. Therefore, these are the situations where they can refer, the subordinate court can refer the High Court. In the case Diwali Bai versus Sadashiv Das, it says about reference made must be made before passing of the judgment of the court. Diwali Bai versus Sadashiv Das. And there is a procedure for every section, right? Well, in CPC we say that as orders. Order 46 under section 113 says about procedure of making a reference. The suit or appeal must be pending before the court while making a reference, and no further appeal from the order of such suit or decree is lying before the court. There should be a pending before the case while there is a reference by subordinate court to the High Court. The question of validity of provisions of law must have arisen during the pendency of suit, i.e., during the proceedings of the suit in the case. The question of validity is raised while proceeding where the procedure of the case. When such doubt regarding the validity of provision of law has arisen, the court must have been entertaining the suit. They must be entertaining the suit. The subordinate court must have been entertaining the suit. And while making a reference, the district court can put the case on stay. Remember the point. While making the reference, the district court can put the case on stay. In the case Ramakan Bindal versus State of UP, it was decided that no reference can be made by a tribunal. It was decided that no reference can be made by a tribunal. I hope this is an important point. Ramakan Bindal versus State of UP. Okay. The reference can be made in suit, appeal, or execution. Proceeding pending before the court only when there is a doubt of law. There should be a doubt of law from the subordinate court to refer it to the High Court. This is all about section 113. Now let's see about section 114. Section 114 says about review. Review means reviewing the case in the same court. Okay. Section 114, review and order 47. Section 114 of CPC defines about review. In a case of review, the party who is not happy or aggrieved with the order of the court can file an application for the review in the same court which has passed the decree. It can apply in the same court, okay, for reviewing the case. In the case of Rambaksh versus Rajeshwari Kunnar, it was decided that the option of review is still there even if the appeal has been dismissed or on any ground. Okay, even if the appeal has been dismissed, there is a chance to reviewing the case. Order 47 of CPC defines the procedure to be followed in the case of review. Okay, Order 47 says about the procedure to be followed in the case of review. The decree or judgment is appealable. However, no appeal has been preferred under the law. In case of no provisions for appeal has been mentioned in the law for certain offences, decree or judgment. The court of small causes have passed the decision. The court for small causes have passed the decision. These are comes under Order 47. Let's see the grounds for review. On the discovery of new and important matter of evidence. This can be appealable when there is a new or important matter of evidence is found. Okay, then the case can be reviewed. Or when mistakes or error are apparent on the face of recorded. There is a mistakes recorded while seeing the case. The main object of this section 114, as we discussed in the previous for this, is said in the case S. Nagraj versus State of Karnataka. The procedure of review has been embedded in the legal system to correct the mistakes and prevent any miscarriage of justice. In the case of Ganeshlalal versus Setmul Chen, it was held that taking into consideration of subclause C of section 114, the application of review against a decree passed by a small court is eligible. Decree passed by a small court is also eligible. And let's also know about the limitations. This comes under 30 days under Article 124 of Limitation Act 1966. The time limit is only 30 days under Article 124 of Limitation Act 1963. Moving forward to our section 115. Section 115 is revision. To revise. Okay. Revision means to revise. Section 115 of CPC prescribes revision. The literal meaning of revision is, we discussed earlier, to revise or to look again. Section 115 empowers the High Court to entertain a revision in any case decided by a subordinate court in any circumstances. This jurisdiction is known as revision jurisdiction of High Court. Okay, especially critically examination with a view to correcting or improving. The main objective of this section 115 is to prevent arbitrary, illegal, or irregular exercises of jurisdiction by the subordinate court. Simply, section 115 is revision to it made by the to revise the case. Okay, if there is any errors, every arbitration errors occurred, this can be revised. The conditions for this section 115 are: the case must be decided, the revision jurisdiction is exercised when no appeal is lies in the case decided by the subordinate court, and the subordinate court is decided in the case by exercise of jurisdiction which is not vested in that court by law, it is failed to exercise the vested jurisdiction, or it is illegal exercise of vested power or with a immaterial irregularity. In the case of Major S.S. Khanna versus Brick F.C. Zillan, it was held that Supreme Court that the court has to take into consideration several factors before exercising the revision jurisdiction. It must take several factors while exercising the revision. The time limit for this is 90 days under Article 131 of Limitation Act 1963. The time limit is 90 days. Coming into the conclusions, we can say that Section 113, Section 114 and Section 115. Section 113 and Order 46 is a reference. Reference means to refer a case. Subordinate courts refers a case to High Court where it feels that it's out of their limit, or it is where it is not mentioned. It subordinate courts refer a case to High Court under Section 113 of CPC, and Order 46 says about the procedure. Okay, reference and review. Section 114 is review. Review means to reviewing the case in the same court. It means to reviewing the case in the same court where there are errors occurred. And section 115 is revision. Revision means to revise the case. The case must be decided, and under section 115 it is the revision. Okay, now let's see the differences between these three. Section 113 Order 46 is reference, Section 114 Order 47 is review, and Section 115 is revision. Okay, reference means in subordinate court refers a case to High Court, it is reference, or in review it is by the same aggrieved party, in revision by the suo motu or aggrieved party. Here in reference, High Court alone decides the case. In review, by the same court, the case was decided, and comes to revision related to jurisdiction error, the case was decided. We're coming to a reference, reasonable doubts of question of law. There should be a reasonable doubts or question of law. While coming to revision, after passing of order or decree, the case must be decided, or while coming to revision, where no appeal lies. There is no appeal lies. And coming to reference, during pendency, the case was decided, and order granting review is appeal. Order granting appeal is review is appeal. While coming to revision, order passed in exercise of revision is not jurisdiction is not applicable. It is in revision it is not applicable. These are the differences between reference, review and revision. I think I covered most of the points. I hope you like the video. If you like the video, please do like, share, comment and subscribe to Law Putra YouTube channel. Thank you.